Hello guys, today I'm gonna talk about end of chapter business law. This video especially made for Madam Zulaika binti Zakaria. First, I'm gonna introduce myself. My name is Alendra Tekusha Anna Benedict. I'm from DPM3C and my matrix number is 05 TPM22F2093. Here is my partner.
Hi, my name is Heather Dumin Sheping Anak Yosha Garang, matrix number 05 DPM 22F2026.
I'm gonna talk about what is termination of agency. The termination of agency is an agency that have been existed can be terminated in different ways. Termination means the ending of the contract of agency between principal and agent. Next, there are three ways an agency relationship can be terminated. First, by agreement. Second, by agent's renunciation. Third, by performance. First, by agreement. When both parties desire and agree that the agency shall terminate it, the agency is terminated. In this method, both of the principal and agent can agree that the agency is to come to an end. Reasonable notice must be given depends on the fact and circumstance. Second, by the principal revoking the agent's authority. The principal may revoke the authority of the agent at any time before it has been cited to bind the principal. The principal can revoke the agent's authority where first, the principal gives notice to the agent. Second, the agent is in a default under agency. However, the power to revoke the agency by the principal is limited to Section 55 of the Contract Act. The agent has an interest in subject matter. Third, by the agent's renunciation. An agent may terminate when the agent surrenders his or her authority and by doing so ends the mandate given to him as an agent. The agent can terminate the agency by giving reasonable notice of termination to the principal. You can find this on Section 159 of Contract Act. If the notice is given, the agent will no longer be liable to the principal and he can claim reimbursement for all his services and expenses up to the date of the termination. Next, I'm gonna talk about what is NEMO that quote non-habit rule. As a general rule, when a person takes goods, example as buyer, he or she gets only the same rights to the goods as the person from whom he or she took them, example seller. This rule is expressed in the Latin maxim NEMO that quote non-habet. The rule is set out in a section 27 Soga in 1957. The provision means that if goods are bought from person who is not the owner and who does not sell them under the owner's authority, the buyer does not acquire any title. First, sale by a mercantile agent. A mercantile agent is a person whose ordinary business is to sell goods or consign them for sale, or to buy goods, or to raise money on the security of goods. However, according to Section 27 Soga 1957, where mercantile agent is, with consent of the owner, in possession of the goods or of a document of a little thing to the goods, any sale by him when acting in ordinary course of business of a mercantile agent shall be valid as if he were expressly authorized by the owner of the goods to make the same. Second, by the one of joint owner. Goods may be owned by one or more than one person. In Section 28 Soga 1957 provides that if one of the owner of goods has the sole possession of them by permission of the CO owners, the property in the goods is transferred to the buyer who buys with good faith and has no notice that the seller has no authority to sell. Thirdly, sale by a seller in possession of the sale. You can find this under Section 30, Clause 1, SOGA 1957. If a seller resells to a second buyer, the second buyer will obtain good title to the goods if he has received the goods in good faith and without notice of the previous sale. The first buyer will lose the title, but he or she can take legal action against the seller who will liable to him. That's all from both of us. Thank you and have a nice day.